I have had many cases, and some stand out in my mind. For instance, a attempted murder case involving a robbery where I was in court and the prosecutor brought in a witness who we really didn't think was necessary, but she was a diligent landlady and she was checking on the rent. And the reason for bringing that witness was because the state wanted to prove a motive, that our clients hadn't paid the rent, needed money. But what the state didn't see was that this witness was there right on the date of the robbery and had seen a vehicle relating to another person, a brother of the co-defendant, who we said was actually the robber. And so that brother had claimed through earlier statements that he was in Tampa or some other place on this particular day. But here the landlady came in, unbeknownst to us until the trial, and gave us a gift that, hey, this person we say committed the robbery, his car was parked in the driveway a few blocks away from the robbery. That, plus some other important gifts that occurred in that case, led us to a not guilty verdict. Because of that high burden of proof that I've referred to, the proof beyond any reasonable doubt, one significant chink in the state's case, depending on the jury, can be enough to create the concept of reasonable doubt. Let me give you another example. You'll all remember the name John Connally. He was with President Kennedy in Kennedy's vehicle when the president was assassinated back in 1963 in Dallas. Well, John Connally went on to become Secretary of the Treasury, and he was indicted for receiving, quote, unlawful gratuities, which means bribes. And the key witness against John Connally was a man by the name of Jake Jacobson. Jacobson had given a story initially to the FBI that he, Jacobson, was the person who transferred the money, and he used a glove, a rubber glove, to count all this cash. Well, when the case got to trial, Jacobson got on the stand and changed his story and said at the trial he had used rubber gloves. So the defense lawyer, a very famous lawyer by the name of Edward Bennett Williams, cross-examined Jacobson and said, why did you change your testimony? You said glove to the FBI, but now you're saying you use rubber gloves, because obviously it'd be kind of hard to count a bunch of money with one rubber glove. And Jacobson said, well, the reason I changed my testimony was it sounded more logical that I was wearing rubber gloves. That, plus a couple of other small inconsistencies, led to an acquittal of John Connally, the former Secretary of Treasury, one of the highest positions in American government. So, an open window, a closed window, what a person does when they look into a door and see someone committing a crime, and then close the door and casually walk away, but then come to court and claim that they were outraged and this was a huge crime that they observed, yet their actions belie what they're saying. No reasonable person would do what they say they did. So many small, apparently unimportant details can actually win the case.